Ready, start. Public consultation cannot be reduced to a mere incantation or a procedural formality which has to be completed to move on to the next stage. Underlying public consultation is the important constitutional value that decisions which affect the lives of individuals must, in a system of democratic governance, factor in their concerns which have been expressed after obtaining full knowledge of a project and its potential environmental effects. Deliberative democracy accentuates the right of participation in deliberation, in decision making, and in contestation of public decision making. Contestation before the courts post the decision or legislation is one form of participation. Adjudication by courts structured by the legal principles of procedural fairness and differential power of judicial review is not a substitute for public participation before and at the decision making stage. In a republican or representative democracy, citizens delegate the responsibility to make and execute laws to the elected government, which takes decisions on their behalf. This is unavoidable and necessary as deliberation and decision making is more efficient in smaller groups. The process requires gathering, processing, and drawing inferences from information, especially in contentious matters. Government officers skilled, informed, and convergent with the issues and political executive backed by the election mandate and connected with electorate are better equipped and positioned to take decisions. This enables the elected political executive to carry out their policies and promises into actual practice. Further, citizens approach elected representatives and through them express their views both in favor and against proposed legislations and policy measures. Nevertheless, when required, draft legislations are referred to parliamentary committees for holding elaborate consultation with experts and stakeholders. The process of making primary legislation by elected representatives is structured by scrutiny, consultation, and deliberation on different views and choices infused with an element of garnering consensus. It is no doubt true that South African constitution obligates the duty to inform and consult, albeit it would be wrong to state that this obligation and the right is a utopian and an impractical proposition in electoral democracies. India itself is a shining exemplar of how the citizens have been indirect participants in primary legislations. By contrast, indirect public participation in delegated legislation gets restricted, an aspect highlighted with reservations in earlier judgments of this court. Traditionally, this has passed judicial acceptance for several reasons, including exercise of keen legislative oversight over executive agencies, thereby ensuring integrity of the collective rule. This concern can be, however, be addressed by adopting good governance principles or by way of legislative mandate in the enacted statutes, rules, and regulations. In fact, we have several legislations which mandate public participation in the form of consultation and even hearing, with an objective that the decisions and policies take into account people's concerns and opinions. Public participation in this manner is more direct and of a higher order than primary legislations enacted by elected representatives. However, delegation of the power to legislate and govern to elected representatives is not meant to deny the citizenry's right to know and be informed.